Sir, it's a privilege to have you with us today. You have represented the Union of India in some of the most consequential constitutional and economic matters of recent times, from taxation of online gaming to questions of fiscal federalism and the limits of judicial review in policy making. Your courtroom arguments often emphasize the discipline of governance within the constitutional framework, and we look forward to hearing your perspective on some of the following questions. Firstly, sir, I would want to know about the exhibition that you just viewed. How do you perceive it? What is your opinion about the foot forward by spiritual leaders in such space?
I can say I've not found out a more compelling, more channelized and bringing out the quintessence of our land and what it stands for within just 10 or 12 slides. The capture is very, very impactful and highly deep, and wish it penetrates well.
With that, sir, I would want to come to my next question, which is, what is your view on the opinion of His Holiness Spiritual Sovereign Jainacharya Yugbhushansuri ji?
See, if you see this exhibition, what attracts the most is when the Western world preaches more and more into individual rights. This exhibition brings out the strength of our land, which lies in its institutions. Marriage is an institution. Family is an institution. Society is an institution in which individuals play a major role, a very cohesive role. Now, if you attempt to diverse these three institutions and calibrate only individual power as mightiest, then you will be left only with individuals and not institutions. So this exhibition brings this at the forefront, that this is what is happening and this should not happen. And that's why I say it's very unique and it's extremely good.
Right. With that, sir, I would want to come to my next question, which is generally between the state intervention of the fundamental freedom under Article 25. How do you view that? How do you see? Where do you think that the line should be drawn here? That this much is the state's domain, and now this is the individual's, freedom to practice his or her faith in this manner.
See, this has been said many times, and either you can give a very elaborate answer or a short and sweet answer. Considering the time, I'll give a short and sweet, but it requires deliberation. See, you can give an answer either in a very elaborate way or in a very short and sweet way, which I'll prefer the later for today's interview. This is what we should understand. 25 is also part of part 3. So, whatever right you envisage and guarantee in other articles, you must also guarantee that for 25 with the operating constitutional regulations or even limitations, which are what? Public order, morality. These are all the exceptions carved out in 25. Now, what is happening over a period of time? I wouldn't say it is done with some deliberate design and all, but it is happening. So, we should be very conscious of it. Somewhere, Article 21 is now taking over Article 25. Yes. You breathe more and more individual liberty into 21 and allow it to dominate. It will have a shrinking impact on Article 25. And this is something which we should be very careful, very conscious, and see how to handle it for the future generation.
Very correctly pointed out.
So, what is happening? There is a huge shift from faith to rights.
Right.
From people reposing faith, people demand rights. And how does this transition happen? It happens because 21 is now doing a dominating role over 24.
Very well pointed out, sir. Very, very novel perspective on the interplay of Article 21 and 25, I must say. In that context, sir, we'll move to this one-liners on Constitution, where we would want to have your instinctive thoughts on certain questions. The first one being, between Parliament, Executive and the Judiciary, which institution do you think commands the most public trust today?
I think this question should be reframed. We should always ask, how are we going to endeavor to ensure that people pay trust in all the three institutions in the same degree? That should be the question, and that should be the path. We should not disfigure these three constitutional institutions. See, sovereignty is one concept. Beneath it works these three organs. And who is the supreme holder of sovereignty? People. That's exactly the constitution. Who sovereignty rests with the people, not with these three organs. Therefore, it is people's mind that decides the fate of these three institutions. So you can't take this institution in isolation and say demand it. How do we encourage trust? How do we develop trust in the people, which will have an impact in ensuring all the three constitutional organs work in sync and with trust? That's how this question should be framed in my view.
Absolutely, absolutely, sir. Understand. Okay, with that, the second and the last question of this segment is, if you could amend one part of the Constitution to strengthen democracy, which article would you choose and why?
There is no need for an amendment, but certainly the freedom of speech requires a little more thoughtful consideration in future matters. Rights along with duties, rights along with regulatory powers. So unhindered freedom of speech, communication, circulation, a media presence, social media impact, unhindered. How far it is good or bad, history, countries which has practiced in a very unhindered way, history has shown where it has finally landed. We have a history before us. So we can look into that and ensure what is the best optimum sync we can obtain. Every right should be calibrated. There is nothing called unhindered in the Constitution. So this is something which we should be careful about, is my personal view.
So, sir, you have just gone through the mini exhibition that we have had here, and outlook of that. How do you see the impact of that on the judiciary's perspective? How do you see that it can help in reshaping judiciary's approach?
If you want a frank answer, it will take a lot of time. This is how I see the exhibition. This can have an immediate impact if you are able to turn this and impact this with our next generation children and youth. See, change can be brought only by youth. Wisdom does the change, but wisdom does the change based on the impact which youth reflects. This is how historical changes have happened in civilizations. So, without a demand, you can't expect constitutional bodies to proactively do changes. In a constitutional democracy, that's not going to happen. It should be very clear. So there must be a demand. See, the constitutional democracy works on two verticals. One is social digestibility. Another is social demand. To give you an example, a public interest litigation was filed to demand rights for Sabarimala, which was absolutely not a right which can at all be conceived within the matrix. It's a personal view. The court upheld that right. But what happened? Millions, lakhs of women in Kerala came out to the streets and said, we never asked for this right. We don't want this right. So, when you deliver something from a constitutional body, you need not have to deliver a popular view. That's the incorrect approach. but you must be able to deliver a view which is socially digestible at that point of time. You can't be ahead, you can't be behind.
Correct.
Constitutional bodies, including judiciary, to that extent can be an aid. But this will occur, the second will occur only when there is a social demand and social insistence.
Right.
See, today, last 10 years, you see what is happening. The demands are all for individual liberties. Much of court's time and attention is drawn towards that.
Right.
It may not happen that the entire India or the entire citizenry is wanting for that, but that is how it is being projected. So, court's time will occupy attention only on such issues which is brought before it.
Correct. Correct. Absolutely, sir.
If you bring this ideologies which is so beautifully picturized, it is so eloquently put, I should say. Step by step it has, I'm not, many of us have these ideas, but I have not seen someone putting it together in a sequential steps. The exhibition reflects that certainly. So, if this can come as an issue before a court, then court has a role to play.
Right.
But for it to come before a court, society should reflect on it and then say, we want this.
Demand.
See, I will wind up with this, maybe take an extra minute, but what our court has very recently held, the constitutional bench in the EWS matter, basic structure is an important doctrine, but doesn't mean basic structure should remain a static structure. You can't say for next 300 years, the principles enshrined as basic structure today will be the basic structure even after 300 years. So the court has given a small window. Every society at that point of time should be granted the liberty to determine what their basic structure for their life should be in the constitution. It's a very
Right.
nuanced idea. So they have not broken basic structure. They say constitution demands basic structure, but it can't be static. It has to be dynamic. So people of that time, they should demand what they want, and that is people's voice. That is sovereign voice, and therefore the constitutional bodies should calibrate it. It's the pathway laid today by judiciary on this point.
Absolutely, sir. What a wonderful perspective, sir, I must say. Thank you so
Thank you,
much. We are very grateful for your time
It's
today.
my
Thank
duty.
you.
What little we can do for our nation. Namaste.
Thank you.